Okay, we'll call the meeting to order of the State and Local Government Subcommittee. Representative Chair Lady Mary Margaret Oliver, would you like to go ahead and present 66 at the podium? Thank you.
Thank you, Mr. Chairman. May I know who is with us by Zoom? I'm not sure if I can see that at this point.
We have B. Nguyen and Representative Shannon and Representative Victor Anderson.
Okay. Thank you, sir. I appreciate it. We had a very good discussion at our last subcommittee about House Bill 23, 24, and 66, which as a package of bills was introduced, pre-filed by me and then introduced in January for the purpose of creating greater transparency on development authorities and their impacts on local governments. And secondly, for the purpose of eliminating a gray area about whether or not school systems or other local governments had the right, the authority to be in court at bond validation hearings. As I said in my last discussion about the arbitration appeal process for annexations and the procedures around the arbitration panel reviews, I've consulted with lots of different folks on this important area. ACCG and Georgia Municipal Association and the developers and various bond lawyers have all been very helpful to me, and I'm grateful for their assistance. At our last hearing, Chairman Fleming had a specific, it's one of the reasons I asked if he was on Zoom, because I wanted to respond to his suggestion that in relation to the provisions that were set out in House Bill 24 specifically, that I not relating to notice, that I'm going to talk about in a little bit more detail, that I not put the provision that development authorities should give notice of their tax abatements or finals incentives to local, not put it in the bond validation statutes, which are in 3682, 76, and 77 specifically. He said that he thought that there'd be less concern by the bond lawyers if I moved it to the development authority. So the substitute that I'm offering today, which we'll discuss for the committee, is LC 470819S, which requires that anytime a development authority is proposing a financial incentives, tax abatements, revenue bonds, or other revenue obligations that in the form of bonds and tax abatement negotiations with developers, that they be required to give notice to the local government that's impacted. This is in the Development Authority statute, which is 3662, and not in the bond validation section, to follow Representative Fleming's suggestion. We know right now that as a matter of law under 368276, the bond validation procedures that development authorities have to follow, that they are required to do a legal notice in the newspaper after a judge has set a hearing on the bond validation. The statute that I've given you does not require the notice to contain any information about the deal, about the tax abatements. And if you're in a large county or really a county of any size, the possibility of a local government missing the legal advertisement is fairly significant, I think. It certainly is true in the metropolitan large counties, in whether they're Augusta, Macon, that the county legal organ is the only place that a city might know of a development authority's intent to seek bonds and reduce taxes for a potential development project. In our testimony in our early hearing, the development authorities came forward and said they always tell their neighbors what they're doing. And I have specific information in a variety of settings where that's just simply, they haven't been good neighbors. If you are a good neighbor and you're going to abate taxes for a school system, I'll use that as an example, then you ought to give them notification of what you're doing, and you ought to give them notification of the financial deal and the specific financial impact it's going to have. And that's what is the purpose of House Bill 66. Specifically, any affected government, 7 days before the court hearing, just 7 days before the court hearing, the development authority shall provide specific information on the financial incentives that are offered in the bond validation hearing. And it goes on to say the written notice shall be an analysis of the project subject to the contract and financial incentives, not limited to information whether or not the project would be feasible without the incentives. I'm offering for the committee's consideration that LC 4708198, and I also have one amendment to that that's been suggested by the Development Authority of DeKalb County as an amendment that he preferred that it be added. The issue of standing for the school systems and the local impact, I'm not going to address in this hearing at this time. I think that that needs to be addressed, but it may be something that we can wait and look at in the future. I feel strongly that at this time, a provision that merely requires the development authority to give notice to impacted governments of the financial details of the deal that they're setting that takes away taxes from the local is a very modest, responsible step for the General Assembly to assert, given the fact that we have a great deal of conflict or discussion or litigation around these issues in the areas of the state where there's a lot of competition. Many folks say to me, this is only a problem of Fulton or DeKalb. And I know for a fact that it's not only a problem of Fulton or DeKalb. And wherever there's competition and wherever there is an opportunity to create new economic development, there is an opportunity and an obligation for the development authorities to at least tell the counties and the school systems and the cities they're impacting what financial incentives they are offering. I'm happy to answer any questions. And as the committee knows from the last hearing, this bill is supported by the Association of County Commissioners and specifically DeKalb County also.
Thank you, Ms. Chair Lady. Do we have any questions by any members of the committee? Any of them on Zoom? Have any questions? No, we could actually vote on it. Does anyone here wish to speak for or against the bill? Yes, ma'am. If you'll come up to the podium.
Hello, Kathleen Bowen with ACCG. I just wanted to go on record that we do support the changes that Representative Oliver made to this bill. Our members studied this issue over the summer, and this is one of the issues that we think should be addressed, and it is a statewide issue. And her bill does provide notice to all of the local governments that could be affected by a development authority abating their taxes. So we do think it is a good step in the right direction, and supporting it will at least allow us to continue these conversations. So if there's not any questions, I will take a seat.
Does anyone have any questions for Ms. Bowman?
Thank you.
Thank you. Anyone else wish to be heard on this issue, on this bill? What is the will of the committee?
I move, Mr. Chairman, that LC 470819S to substitute the House Bill do pass.
Second.
Second.
Who did the second?
Representative Shannon.
We have a motion and a second. Any discussion? Yes. What's your number?
Just to clarify, it's the substitute as amended.
I was just going to offer an amendment. I thought.
So,
procedure-
sorry, I'm jumping ahead.
Well, I think that we now have a motion for passage of the bill. Now, Mr. Chairman, that we have a motion and a second for passage of the bill. It's a time for discussion, and then the chair, if he wishes to, call for amendments, and I have an amendment I'd like to suggest. The amendment I wish to offer that's been offered out to the committee is one that's suggested by the legal counsel for Development Authority to CAB. And on line 22 of the substitute, after the word provided, it shall insert the providing the location, functional description, and the extent to the available general physical description of the project that is subject to the proposal, as well as financial incentives offered. Offer that amendment.
Okay, do I hear a motion on that amendment?
I move for that amendment, Mr. Chairman.
I'd like to second, Mr. Chairman.
Okay. Number 10, is that you, Chairman Collins? You're what?
Before you call that vote, GMA want to weigh in on this at all? I know we heard from ACCG, but
Yeah.
this is a procedural change that's going to affect a lot of.
Would you like to be heard on it?
Sure, Mr. Chairman. To my friend and former mayor, Representative Collins, thanks for putting me on the spot. We had not planned to testify on this measure. Representative Oliver has been working with us since, I want to say, October on this legislation and other bills that have been pending before the Governmental Affairs Committee. She's put a lot of hard work into this, and we know that there are debates about the use of tax abatements, particularly when they do impact other local governments that share territory. These votes at the end of the day are taken in a public forum. We do think that some of our members will be very much in favor of more transparency. And we may have others that see the need to keep as much of this close to their vest in the negotiation phase as possible. But we think she's trying to address this in a good faith manner, and we're at this time neutral on the legislation.
The Municipal Association was a little nervous about the provisions I talked about last time about adding standing to the annexation tribunals under DCA, and so I moved away from that at their request. The reality here is that it's hard for GMA to stand up and say, I'm for secrecy. It's really more relevant that they're going to stand up and say they're for transparency, and I think that's why they are officially neutral on this.
Thank you, ma'am.
Thank you very much.
Okay, thank you.
Thank you.
Any other questions of GMA or anyone? We have a motion and a second on the floor
For the amendment.
for the amendment. Motion and second. All in favor, say aye.
Aye.
All opposed? You voting? Aye. So pass.
Thank you. Is that,
And it passed on the House. Now, what about the Zooming people? Did they wish to vote?
Mr. Chairman, was that a motion for due pass as Subcommittee substitute as amended. Is that the motion that we were just voting on?
That's what we did, took a vote on the amendment then. Now we'll take a motion on the bill as amended.
Thank you.
Okay. What is the will of the committee?
Aye.
Do pass. And a second?
I'll second, Mr. Chair.
Okay, Beaton Wynn seconded. Any discussion? All in favor?
Aye.
Aye.
So carry.
Thank you.
Any opposed? So carry. Thank you.
Thank you, sir.
Representative Benton. How about 221?
Mr. Chairman, if it would please the committee, I've got two bills on the docket today. Would it be possible for me to go to 222? I've got people here that are wanting to speak, and
Sure, we'll
I'd
go
like
to
to get,
222
like to
first.
get them started home before the Gwinnett grind starts.
Yes, sir. 222 will be fine.
House Bill 222 it was a bill that was offered by me, and this bill does one thing. It abolishes the charter of the city of Pendergrass. And you say, well, why would you do something like that? Why would you take this method of trying to solve a problem? Well, the problem that we have is greater than the resources that we can do in order to try to solve the problem. And talking with legislative counsel and with the attorney for GMA, everything that was suggested to try to solve this problem either ran afoul of the state constitution or Pendergrass's right to home rule, that the only method that we have left is to abolish the town. Now, the reason for abolishing the town is because for the last, and I'd say probably 25 or 30 years, the town has been run by one family. And that one family has, of course, consolidated its holdings within the town. For a long time, the town did not grow. It just stayed basically the same size, but between several censuses, maybe gaining a few on one and losing those in the next one. But in the last few years, we have, because of the growth of Jackson County, we have seen a tremendous upsurge in what's going on in towns all across the county. Most of them run very well in their zoning and their use of their power to bring about some changes. But what we've had happen in Pendergrass is the mayor, whose family has run the town of Pendergrass for a long time, and the city administrator have gone about in their actions within the city government that is advantageous to them, not advantageous to the city. The major part of the property that is inside the city limits is owned by the mayor or his family. A good many of those homes that are on that property are rental properties. We have the mayor, we have a city council that is made up of people that work for him, rent for him, or a family. And so the zoning process is really skewed to start off with. But what we're proposing here is for the town to be abolished, and that the Jackson County government take over all the functions that were being done by the city of Brownston. I do want to point out that and I don't know what all the requirements are to be a town, but if Pendergrass, I think, was trying to become a town today, it would not meet those requirements. It does not furnish enough services to its taxpayers, its homeowners, and so forth. But we are looking to have Jackson County come in, and it'll be vested with the full authority to run the area that used to be the city of Pendergrass. Now, the city of Pendergrass and the last audit that we have to go by is the 2018 audit, which indicates to us that the 19 either was not done or it's not out there, and the 20 I don't think is ready to be done, is finished yet. But Pendergrass is sitting on a tremendous liability. It lost a court case several years ago on a whistleblower case, and those employees that were fired won a judgment against the city, including legal fees for $1,200,000. The city also owes for money that it borrowed on a town hall and supposed to be a library. And it also owes the attorney that they used, attorney's fees that are over $300,000. And so you've got the city of Pendergrass that has assets in the neighborhood of around $400,000, and it's going to have a judgment against it that it's going to have to pay, and it does not have the resources to pay that. And so we're giving in the bill, we're giving Jackson County the authority to set up a special tax district in order to pay those obligations that will first sell off the assets of the city and then pay those obligations. We are allowing the county to do this special tax district until the payment is done, and then that tax district will be removed. Right now, the citizens of Pendergrass, the property owners of Pendergrass, pay 3 mills in taxes. If Pendergrass stays around, the judgment comes around, that millage rate could go up significantly. A lot of people in Pendergrass do not realize that they're going to have to pay this judgment. And so, so the financial assets and the property will be devolved to Jackson County and will be used for the purpose of the Pendergrass district to satisfy any obligations and retire any indebtedness of the city of Pendergrass. Anybody that is, the county is not responsible for anybody that is working for the city of Pendergrass at this time. And Pendergrass does allow for liquor sales, which the county does not, and that would be that business would have to revert back just to beer and wine sales only. All the zoning and land use regulations of the city of Pendergrass will be deemed Jackson County ordinances and shall apply within the Pendergrass Service District only until Jackson County adopts zoning and land use regulations covering the properties within the Pendergrass Service District. I know that this is a drastic step for this, and I do it reluctantly, but I have tried to work with the mayor and city administrator. I know that GMA is going to come up here and be opposed to this. If they were the first people that I talked to several years ago when all this came up, when a citizens group tried to recall the mayor and city council because they had no representation. All the members of the city council were coming from one area of the city because it was an at-large election. And if you went to look at trying to apportion Pendergrass, all the or most of the citizens lived in one or two areas. The rest of the area was farmland or industrial use. If we look at all the things that have gone on, and we look at the audit that Pendergrass, the last audit that we have, some of the things that are going on in their banking accounts, they are keeping more in those accounts than the FDIC will cover if something should happen to the bank. They move money around. They don't keep, it's all in a general fund. It's supposed to be kept in separate accounts. They misused $25,000 of SPLOST money several years ago, and they're having to pay that back. It was $25,000 is what they took from SPLOST. We don't know what that was used for. We know what was the SPLOST was there for, but we don't know that that was what it was used for. They have not paid their dues to the regional commission, which they're required to do by law. Their intergovernmental financial reports are not generated for fiscal activity. Financial statements are not available in some cases for more than 12 months. All of this is blamed on employee turnover. Their bank reconciliations are not balanced. And as I mentioned, their general fund owes SPLOST money. They do not have a plan. They did not have a plan in 2018 to repay that money. The approved budget was not balanced by funds and expenditures. They just, if they have a bill, they just pay it. And they don't amend their budget. The expenditures approved and paid without consideration of budget limits. They used excess funds to pay attorney fees without amending the budget. And all this came from a audit that was done by Bates, Carter and Company. And I don't know what they're out of, but I'll be glad to answer any questions that you have. And I've got several people that like to come speak to the bill.
Okay, I think we have some questions. Let's see. Representative Shannon.
Thank you, Mr. Chair. I have two questions for the bill sponsor. I see, the first question is, can you go over the numbers again about the debt? Because I thought I heard you say that there was only $300,000 in assets, but the judgment that was going to come down is more than $1 million. And I see where it goes into that special tax fund. But who pays? Was that right that there's only 300,000 in assets?
All right, the capital assets are right at $400,000. Their overlay projects are about $125,000. The outlay project, and they will owe their legal judgment payable is $1,222,270. Their note payments are $626,590. That's $1,992,723 that they owe.
So who's going to pay the difference? I see where it goes to the special tax fund, but your bill says that the county is not responsible for any debt unless it's bond indebtedness. So who is going to, even though it goes in this special tax fund?
The bill gives the county the authority to pay the debt, but they will then collect the debt from the special tax district. And that special tax district will be made up of all the properties that were part of the city of Pendergrass. They were going to have to pay it anyway when the judgment came through.
Yeah, but it sounds like, so this kind of leads to my second question, because you said that are you saying all the property, because it kind of sounds like a city has been created, a mess has been made, and now the people who lived in that city want to be dumped back into the county to avoid having to pay the bills, which this judgment is coming from. So you can make a mess and then spread out the mess amongst the county taxpayers who weren't involved in the city, is what it sounds like.
That's the reason we're doing the special tax district, is we don't want the county taxpayer, the rest of the county taxpayers to have to pay that bill. It would be only those people that are in the city of Pendergrass or moved to the city of Pendergrass.
Oh, I see. Okay, thank you for clearing that up.
Yes, ma'am.
What does Jackson County have to say about this?
Jackson County has agreed to do this. I had them in the office the other day on a conference call along with the two senators that represent Jackson County.
Are the senators in favor of this bill? I know
I'm
it's
sorry.
Are the senators in favor of this bill? I know it's premature to ask.
The one senator is neutral. The other is still weighing his options. I think he's, I don't know why.
How many employees does Pendergrass have?
They've got the mayor, the city administrator, they've got a clerk, they've got 2 policemen that I know of, and then they've got some ground workers that go around, pick up trash and stuff like that.
Section 6A says that Jackson County is not going to be responsible for any debt. And that
Unless they take it on. I think it says in there that either Jackson, especially except as specifically provided in this act.
And that relates back to 4,
Yes.
the tax. Is the special tax district going to be financed only by your liquor sales? I mean, what's going to finance that?
The special tax district will be only to pay off the debts of the city of Pendergrass.
So my question is, where's the money coming from? I mean, is it from
It's
the
coming from the property owners. It would be probably 1 or 2 mills levied for a period of time. They're going to have to pay it anyway. They're paying 3 mills now. And because of the property, I'm not sure whether or not liens could be made against the property and homes as long as that debt's there.
And the other revenue you mentioned and correct me if I didn't hear this correctly, Pendergrass does get revenue from liquor sales.
It does get from alcohol sales, yes. And it gets revenue from 3 mills property tax, and
That's it.
that's it.
Chairman Collins.
Hey, I was just looking on the map. The interstate, there's not an exit in the city of Pendergrass.
No, it's about 1.5 miles from the city of Pendergrass,
Okay, that's north of Pendergrass, is that correct?
south of Pendergrass.
Okay, all right. So is that exit in another incorporated area, or is
It's
that?
in Jefferson.
Okay.
Okay, let's see. Representative Wynn.
Thank you, Mr. Chair. I just have a couple of questions, not necessarily about the merits of dissolving the city itself, but just about how this has traditionally been used. Have we dissolved other cities in the state of Georgia previously?
We have dissolved. I don't remember. Seemed like there was one done maybe in, I was going to say Fulton County, but I'm not sure. It's not something that we generally tend to happen, but a lot of times 2 cities will merge and come together on something like that. But I was trying to do since we couldn't fix it by doing away with the city council and mayor, because I felt like you couldn't prohibit those people that hold those offices from running for them again. And so then you end up with the same thing all over again. I suggested and I was throwing these suggestions out to legislative council about some things that could be done. But it seems like everything that we did, I even thought that maybe if we did away with the mayor and city council, we could get the county grand jury to appoint an administrator for several years, but we can't do that. And so you're either going to be stuck with people that are in this for themselves. And I'd also want to point out that the mayor and the city administrator are in business together in realty, developing real estate. And of course, all of this has had a really adverse effect on the county school system. because the school that was up there was small. They're already hauling in trailers now. It's on a septic tank. I heard today that they're pumping that septic tank twice a week now because of all the growth that's happened because of these developments. And so something has to happen to rein some of it in and maybe do away with the rest of it.
Follow-up question. I'm not necessarily opposed to the bill, Representative. I just, when we form a city, there is a voter referendum. And so in just thinking about dissolving a city, how is there assurance, I guess, that the residents also are in favor of this?
I don't know. I know there's a good many that are opposed to it. I think all total, I've gotten 5 emails of people that were opposed to the bill. Most people that live in Pendergrass, they leave their homes and they either go to the interstate there at the exit at Jefferson, or they go to the interstate over to exit at Brownston, and they come to Gwinnett County, DeKalb County, Fulton County to work. And when they come back in, they don't pay any attention to what's going on in Brownston. Some of the emails that I've gotten, they say, how could this happen? How could all this happen? Well, it happens because people are not informed, and they're not. And as far as the city council is concerned, they have meetings when nobody can attend at 9 o'clock in the morning, and they don't advertise these meetings. They, we happen to have people that are community minded and will go to these meetings, but the mayor will preside over meetings in which his property is the ones that are being discussed. And he's looking for somebody else on the council to make a motion, and he's right there in the meeting. And so it's, at some later date, that area might want to try to reincorporate, but right now they're a mess, and we don't have any way to fix it other than this right here. Did I answer your question, Representative? I'm sorry.
Oh, yes, you did. Thank you.
All right.
Thank you,
Thank you.
Representative.
Okay. Chairman Collins.
I know there was a city out in my area, Lithia Springs, that was dissolved several years ago. I don't know, Chairman Oliver, you may remember that. It was the city of Lithia Springs, and I think they came to the legislative body and asked for that to happen and occur. And Chairman Benton, I feel for your position that you're in. The only thing that scares me about moving forward with this is the precedent that we set, simply because when you have, well, first of all, let me say, if every time we felt like a city wouldn't be running correctly, and the books weren't being taken care of, we came up here and dissolved the city, there wouldn't be a whole lot of cities left in the state of Georgia, in my opinion. That's my only concern. Is I know you probably have some people here that want to give testimony today.
Yes, sir.
And I look forward to hearing that. But my only concern at this point, based on what you've shared, is just the precedent that we set as a legislative deliberate body as to moving forward. So that's really my only comments at this time.
The only thing I would say to something like that was that we set precedents all the time, and this, as I said, this is a last resort thing as far as I'm concerned. It's 10, 12 years ago, the mayor and administrator said they'd clean up their act and everything, but they haven't. It's stayed the same. And like I said, most of the people of Pendergrass don't have any idea what's going on inside the town limits. It's two-person rule. The mayor and the city administrator and the council is there to back them up on what they're wanting to do.
Representative Shannon.
Yeah, I just have a question, and I guess something for the bill sponsor to think about, or hear your comments if you have already thought about it. And it kind of is similar to Representative Wynn's question. I know you said that most of the people don't pay attention to what's going on, but I mean, you could say that for any level of government, that people don't really keep up with watching our committee meetings, this committee meeting, for example. But I guess it just really seems odd for us to, I mean, the fact that you have to vote and have a referendum to get a city, but we wouldn't use one to get rid of a city. That part definitely makes me uncomfortable. Because yeah, it's like if people vote, I mean, there are some people who feel like cities are generally a bad idea, but if people vote for it and they want to be in a city, then I mean, they can, kind of roll the dice. I guess, have you considered adding a referendum to this? And I know you say people don't pay attention in the area, but this would be something they maybe would pay attention to, or maybe it's the case that they like what is going on. Maybe they're satisfied, even though you're dissatisfied with what's going on. Maybe the majority are satisfied with the mess that has been made.
My only problem with the referendum is the fact that the people that are supporters of the current mayor would be the ones that would turn out. The rest of them would just say there's no needing us vote, and they're gonna get what they want because they get the council that they want and they get the mayor that they want.
But my follow-up to that would be, that's called democracy. I mean, we know that something like, even in the national vote for president, we've heard statistics like more people vote for American Idol than they do who's going to be president of the United States. So that just seems like a part of democracy where people choose to vote and people don't.
Okay, I appreciate your thoughts on that. Thank you.
Thank you. Let's see, Mr. Donald Roberts. You come up to the podium, please, sir.
To speak. I would like to thank the committee for the opportunity to speak today. My name is Donald Roberts. I reside at 371 Brothers Road, Pendergrass, Georgia. I have been a cattle farmer and raised my family at this address. My journey that puts me here today started over a year ago. It started with a planned annexation and rezoning that joined my 400-acre farm. The town of Pendergrass was planning an annexation and rezoning of 322.5 acres of agricultural property to a residential and build 8 houses per home, 8 homes per acre. The owner of 205 acres of this property was the mayor of Pendergrass. The mayor had inherited this piece of property and several other pieces of property from his wife, who had inherited it from her mother. My first stop was Jackson County Planning and Zoning Department on Jackson County Use Comprehensive Plan. It shows an agricultural use through year 2040. But the planning department explained to me that the county would have no say on the property if it was annexed into the town of Pendergrass. My next stop was Jackson County Water and Sewer. I was told they were in the business to sell water and sewer. After visiting with many people on this, I was getting the same answers. Everyone told me the same thing. Donald, you're not going to be able to beat this. It's Pendergrass. They do whatever they want. Pendergrass doesn't go by any rules or regulations. I didn't understand. I couldn't not believe what I was being told. I had to find out the truth. I had to see for myself what was going on in Pendergrass government. Starting in January 2020, I attended every city council meeting, all regular meetings, all call meetings, and I am still attending the meetings. I also hired an attorney firm that specialized in zoning issues and familiar with Jackson County. The first thing we found out was that information and documents were not going to be easy to come by in Pendergrass. City Hall, the answer was always the same. Well, I can't put my hands on that right now. Can you come back in a day or two? You'll have to get that from Rob, the city administrator, and he's not in. I returned to see Rob and asked for zoning ordinance, and on the development, I asked for a zoning ordinance from him on the development that they were doing next to me, the annexation, and he said they didn't have one. I said, well, how about a development ordinance? His reply was they did not have a copy and they just went by basic, whatever that means. The town of Pendergrass has a concept of clear, precise, and transparency documents of paperwork. I will let Miss Jane, the attorney, she is here, explain more on this when she speaks. The next question that came to my mind was how one of the city council members, Willie Pittman, got appointed to the city council. He was appointed by the employer, Mayor Talbert. Yes, Willie has worked for the Monk Talbert for many, many years. May I read section 11 under variances of the town of Pendergrass charter. Be it further by authority aforesaid that if a vacancy should occur in the council by death, resurrection, or otherwise, that the election shall be ordered by the mayor or mayor pro tem. Or if both these offices be vacant, the clerk council shall give notice, and in 10 days preceding such election to fill said vacant terms. Said election shall be held exactly as regular elections for the town officers. After discovering of that information, we also found out that Mayor Talbert, Councilman Nathan Pruitt are in business together in the car lot business. And he also helps with the mayor's rental properties. Mayor Talbert is also in business with the city administrator, the planning and zoning director, the environmental and inspection director, and part-time policeman, Rob Russell. How can one man wear so many hats in managing a city? Mayor Talbert and Rob Russell have a development business in Pendergrass. And where do they develop and build? Pendergrass. Let us get back to the council meetings. At the November 20th, 2020 regular monthly meeting, another one of Mayor Talbert's properties came up for rezoning for partial 102-025 containing 19.66 acres. The application asked for R4 zoning and requested 52 lots with a minimum of 7,000 square foot lot. By the end of the meeting, they approved 25.39 acres for R4 zoning with 52 lots, 7,000 square foot lots. The mayor and council approved two partials. The partial in rezoning application, partial 102-025, added a partial 102-A-011. Both partials owned by Mayor Talbert. The several issues with the rezoning, first, they decided to add another partial to the rezoning, going from 19 acres to 25 acres. Second, the minimum lot size in the town of Pendergrass zoning ordinance is 0.25 acres, a quarter of an acre, which is 10,800 square feet. And in the ordinance under section 21-23, regulations cannot be varied. A is a minimum lot size. And the third issue with the meeting, Mayor Talbert chaired the meeting and called the motion for a second for approval. Now, after witnessing this, being completely dumbfounded by what occurred, I later returned to the city hall and asked for the clerk a copy of the November minutes of the council meeting. The approved minutes state that Harlan Robertson asked for a motion in a second. Mr. Robertson would be the mayor pro tem. Now, ladies and gentlemen, I'm sitting in front row of the meeting and I have a video in the meeting on my phone. In the December 2020 regular meeting, there were only two council members present and the mayor. The mayor opened the meeting and declared the quorum present, and the meeting continued under section 10, meeting of council in state. In all, a quorum should be necessary to transfer business to wit, mayor and 3 councilmen. In the state of Georgia, all cities are required to submit an annual budget and an annual audit of accounting. Now, the last audit of accounting was done in 2018. so we have no update audit. We are given a copy of the 2021 annual budget for the fiscal year ending in December 31st, 2021. In my opinion, the proposed 2021 annual budget is greatly underestimated. The money that flows from Jackson County to Pendergrass is much higher than the estimated in planning and building fees, after estimated at a total of $17,000. Within an estimate of over 150 new homes to be built in 2021 and approved lots and residential developments of 542 lots and over 300 acres. Wouldn't it just make sense that income building and development be much greater? And now, where in the budget does it address income from splosh funds? Pendergrass received a total of $109,000 in splosh and money from Jackson County in 2020. Why is Pendergrass not following the open records law for Georgia? Why has Pendergrass been all allowed to operate this way for many years? The issue and problem of Pendergrass goes back decades. Mr. Tommy Benton has had to deal with Pendergrass his whole political career. I know this is a hard, difficult decision for Mr. Benton to make. Pendergrass is an embarrassment to Jackson County and to the state of Georgia. I would like to thank Mr. Benton for writing House Bill 222. It is the right decision for the citizens of Pendergrass and the residents of Jackson County and the state of Georgia. Thank you again for your time and service to our great state. I'd be glad to answer any questions.
Anybody have any questions? Any online? Seeing none, thank you, sir.
Thank y'all.
Mr. Clark, Rainwater.
Get my eyeballs on here real quick. Again, thank you for allowing me to speak, and I appreciate all the things that the two gentlemen have said before. And they're giving you a lot of stats and numbers, and I'm a retired math teacher, but I'm not going to give you any stats and numbers. I'm just going to try to plead to your heart, okay? I'm 66 years old. And I've lived in Pendergrass all my life. And I'm just here, my wife and I, not because of these stats and stuff, but we're opposing what these people do because we're trying to do what's good and try to stop the evil. And the evil is a family. Again, I'm 66 years old. Every day has been in Pendergrass, Georgia. And I could sit up here for probably an hour or so and just tell you all kinds of stories I heard as I grew up and as I've lived through. I'm going to tell you two instances. About 15 years ago, before Pendergrass was a city with a mayor and council and all that kind of good stuff, a little fiefdom is what I call it. They wanted to build apartments right beside my property. Myself, my wife, and about 5 or 6 other property owners that were going to be affected by that, and the school system going to be affected drastically, as it will be again with all the houses they plan on building. Anyways, we decided we would try to keep the apartments from being there because it overcrowded the schools and stuff. We fought against the Talberts, and we won because the county was in charge then, and they saw that the things that we talked about then, overcrowding in school systems and lack of sewer system and other things, would just make things be really rough. So we did battle against them then. And because we stood up to them, ever since then, we've really not had any problems with them. That they don't like somebody like us being here today. They don't like bad publicity, but they're going to sneak and hide and they always have, always will. Whatever you decide, if they get to keep control of Pendergrass, it's never going to change because that family's been in control for all 66 of my years. Same family. Okay, now that same, they didn't have mayors for a lot of that. Didn't have a city council for a lot of that, but the family ran the little community or town of Pendergrass anyways. The second instance is right after we won that, the city clerk or whatever his title is, he also has a couple others, but one was 15 years ago and still is today, he was head of the police department. Well, he came knocking on my door, asked me to step outside, and proceeded to rant and rave and threaten me that we would be part of the city of Pendergrass. Because after the first incident happened, the 5 or 6 families around me decided we're going to get out of the city of Pendergrass, be part of Jackson County. And I'm proud to be in Jackson County, but I'm not proud to even have Pendergrass, the city of Pendergrass, close to us. But because he threatened me and stuff, I really in my heart thought he was wanting to make me do something, because he asked me to come out of my house. And we think, knowing that if I stay in my house, I could probably say and yell and whatever, and nothing would happen. But he asked me to step outside the house, and I did, but I didn't argue with him at all, didn't fuss with him at all. I just said, okay, you think we are, but we're not. And so we proceeded to battle and won again. So they lost. We couldn't be put back in the city of Pendergrass. We have not been, and neither have any other property owners. We're enclosed, surrounded by the city of Pendergrass. And if I die today or die 20 years from now, I fight and do everything I can to keep from being a part of that family and that town. And the last thing I'm going to talk about, again, and I apologize if I'm stammering and stuttering, is our Sunday school lesson this week was the Pharisees and Sadducees were trying to catch Jesus and try to catch him disobeying some of their laws. Some of their laws. You had to do this on the Sabbath. You had to do this on the Sabbath. You had to do this on the Sabbath. Well, Jesus healed on the Sabbath, and he didn't fall into their traps. And I don't know if that means anything to you, but it was just leading up to this. A little part about my speech today is do what's right in your hearts. Vote or however you have to do this stuff, because I don't understand the law stuff, but do what is right. The law doesn't have to be the law. It can be changed some way or amended, and I'm listening to you and I'm trying to understand. But all I ask you is for the citizens of Pendergrass that I feel like I do, just do what is right. And I welcome any questions from anybody.
Thank you. Anyone have any questions? Seeing none, thank you, sir. I appreciate you being here today.
God bless you all.
Thank you. Ms. Range?
Yes, sir.
Thank you, ma'am.
Thank you.
Now, you're an attorney?
Yes, sir, I am.
Okay.
I appreciate being given the opportunity to address you. I'm an attorney in the state of Georgia. I was admitted in 1983. In January of 1984, I went to work for the firm of Hulsey, Oliver, and Mahar in Gainesville. And Julius Hulsey probably might still be remembered by a few folks in local government or GMA or the ACCG. Local government attorney. I started out under him, working with him with Hall County, Georgia, worked with him in Jackson County, Georgia, worked with him in the city of Maysville, Union County, down in Washington County, Daugherty County. We have done specialized work. And one of the things I've done a lot of is zoning work in those 36, going on 37 years. And so currently, our firm, I'll disclose, represents the city of Gainesville, the city of, my name was Jane Range, I'm sorry, I didn't repeat that. And we represent the city of Houston, the city of Maysville, Gainesville, right now in the way of cities. I think one of the partners represents Demarest still. We've represented Blue Ridge. We've represented Blairsville. So I have a lot of time put in working with local government. The reason I became involved in this particular matter is because of the zoning fight. Our firm was hired by Mr. Roberts, and in that period of time, we were able to review zoning adoptions and rules, and the notices, et cetera, for the zoning hearing that he was specifically involved with, but also required us to review minutes of previous zoning hearings where issues were raised with respect to this as initial zoning. And what we saw was a pattern of either malfeasance or incompetence. I have no idea how to judge the motivations of these folks, but items would not be advertised in a timely manner for these hearings. The matters would not be fully described. They, at one point, realized they were challenged on not conforming with the zoning procedures law, and had never actually adopted zoning standards within their ordinance, and had never adopted zoning procedures or ever handed them out at a meeting. And the ZPL is the only state law on zoning essentially that exists, that says you have to give the public sufficient notice and minimum standards and procedures to even hold these hearings. So since the time, and it's not been that long, but in the several years that Pendergrass adopted zoning, there's not actually been a truly legal zoning because none of them were done in accordance with the ZPL. Clearly, upsetting zonings where subdivisions are built and houses are there is not possible. But in terms of text amendments and new zonings, even since the time we have pointed out that those laws were not complied with, and they admitted that the one meeting in early 2020 when they tried to hold and did hold a vote was not properly advertised and therefore not properly adopted zoning ordinance, and therefore every zoning they have done since that time, and they have done several, are still illegal. Now, Mr. Roberts was an adjacent property owner with the zoning that he hired us for, but he's not an adjacent owner who has standing under Georgia law to challenge every irregular zoning. And in fact, most zonings that come up are a piece of property Mr. Talbert or a business partner of his owns. And so these zonings are being done illegally to this day. Our lawsuit, which is still pending and may be mooted if they never proceed with the zoning application, has not changed their behavior. And so one of the things I think that's important to understand is the scope of the problem. In the 2017-2018 update to their comprehensive plan, it was noted that the population in Pendergrass at the time was 456 people, 215 housing units. But back when they collected the statistics in 2017 for their comprehensive plan update, they already had 400 new homes currently proposed. They were talking in excess, of 1,200 homes or more in the subdivision next to Mr. Roberts' property. And so if you look at the average in Jackson County is about 2.8 families per home, 2.8 people per home, and about one child for the school district. The 400 homes that were proposed in 2017 now there's been another subdivision, two subdivisions approved since 2017 that I know of, and they're dealing with now close to a couple thousand units of homes in front of them, not one of which can be legal until they pass proper procedures. In addition, they have not updated the map since the first year they instituted zoning. And so every zoning change is not available on a map. And that was an issue that came up. So now they have a new proposed map. When Mr. Roberts and I attended a July hearing, which was noticed as a public hearing and advertised for map adoption, but when we arrived at the hearing, they announced it would just be an informational hearing, but anybody could ask questions, et cetera. And I took photographs of the maps that they had up, the old maps and the new maps, and noticed that there were several large parcels that didn't match the zonings I was aware of on there that were being rezoned into the highest density zonings. And so at that point, when the question and answer period of the hearing came, I asked if in fact there were zoning applications pending or approved for those map parcels that were being changed. And they said no, they were all the mayor's parcels. And Mr. Russell said he just thought it would be nice to do that for the mayor. Now, maybe he's not competent and he thought that was just something he could do. And so he said they would go back and get maps, but now I heard they haven't paid Northeast Georgia Regional Commission their dues, so they're probably not getting any new maps. And so we're still waiting on maps, but they're still rezoning property without legal maps, which means their zonings are not legal. And that is pretty much how they approach everything in the city, as far as I can tell. And so we're here to point out that it is a series of actions that are illegal that are being taken just in zoning as to what I've looked at. And all of them benefit the mayor. And when called, they stop and you just don't hear anymore. And another issue to support Mr. Roberts on the Open Records Act, in trying to get minutes for these meetings where we had questions as to what happened and what was legal, it would be difficult to get minutes. They would deny they have the minutes. They would hold another meeting and say in the meeting minutes from that meeting, they approved the prior minutes, but they said, oh no, we just have a draft. And so there's never a straight story as to what really happens. And then we would be given two different sets of drafts that said two different things happened at the meetings. So there's nothing that you can rely on from this city council as truth, because you just don't know. Since we were involved in litigation, we requested a certified copy of the planning code, because obviously when you're in court, maybe you're not lawyers, but local regulations, a city ordinance is not law of the state, so there's no judicial notice. And if you're going to litigate over what the code says, you have to put a certified copy in. Mr. Russell insisted that every single individual page had to be certified as opposed to stamping the pages. And he charged over $1,500 for us to get a certified copy to proceed in our lawsuit. So misinformation, abuse of the processes that cost money, repeated applications from us for open records requests that are costing our client money, and a persistent illegal pattern even after informed of the illegality of their zoning. And there's no change. Thank you.
Okay, thank you, ma'am. Chairman Oliver.
I believe that everything you told me about a civil error, civil violation of law would give you an opportunity for, at least under open records, open meetings, for a superior court action that would result in asking for the city to be put in receivership.
Well, that comes at Mr. Roberts' expense.
Who's going to pay for that?
Yeah, that's the problem, is Mr. Roberts has to pay for that to get that started. Now, if we would win, and then we would be one more judgment creditor adding to the city's problems.
I don't know, I do not know the answer to this. Is there any authority of the Georgia Municipal Association to take action to put a city into receivership?
I am not aware of that. I think it's a creditor that has to do it, but I could be wrong.
And why hasn't a creditor done that?
Well, right now, we're not actually a creditor. Our suit is pending.
The judgment is a creditor.
But I don't represent those people and I don't have the money. I mean, I'm not, and Mr. Roberts right now has no responsibility for that, so he's not a creditor.
If I sue them, I'm not going to get nothing because they got a lawsuit pending that they're not paying, so I'll just be wasting my time and money. But this city's got to be straightened out by someone.
I can't speak for the attorney that represented the city or whether he's been paid, but apparently it's still on the books as a $300,000 debt. Don't represent the other ex-employees. And so I think that they've been waiting for the Supreme Court to decide, and then they will move at some point and they may force that.
The issue before the Georgia Supreme Court is what? Is Mr. Roberts' case?
No, it's unrelated to Mr. Roberts. It's the whistleblower case. And so so again, in terms of Mr. Roberts or myself, we are not at this point creditors who could file for receivership.
Thank you.
You're welcome.
Does any of the other members have any questions?
I do, Mr. Chair.
Okay, who is that?
Representative Shannon.
Yes, ma'am. Go right ahead, Representative.
Thank you, Mr. Chair. Just a quick question for the attorney. I know you mentioned a lot of things that they were doing that is illegal with the zoning and stuff like that, but have the leaders of the city, the elected officials, done anything that would rise to anything criminal?
Well, I think that in an opinion is the illegal on a civil level or even penal is not necessarily criminal. And they don't have, as far as I'm aware, an ethics ordinance which would make a misdemeanor out of their behavior. And the state ethics ordinance may encompass some of the self-dealing by the mayor in terms of being present or voting. But no one has pressed charges because when you're in a civil litigation, pressing charges criminally is something that you stay away from unless you have no choice, simply because threatening criminal charges without good grounds is something that for an attorney is a breach of our ethical obligations. We're not supposed to try and turn a civil matter into a criminal matter. And so far, they haven't done anything specifically criminal. I don't think violating the ZPL, the zoning procedures law, is in actuality criminal.
Yeah, I'm just asking because of the combination of your testimony and other folks, and I'll say I don't know anything about this city, so I don't have any allegiance to them or anything like that. But it just seems like the list of complaints. I mean, we see elected officials go to jail all the time. It just kind of feels like if things were really at the level that everybody is reporting about this city, I'm just surprised that nobody is under any kind of criminal investigation or anything. That's what's surprising to me.
Well, I think the whistleblower suit was in fact kind of a combination of that. They were turning in people for extorting speeding tickets or something like that, ticket fixing. And certainly from the state level, Pendergrass was one of the greatest offenders of having speed traps. And they didn't need city taxes back then because I think the state number was that they were getting 367, but I'm a little bit dyslexic. It might have been $637 per citizen in the way of ticket fees every year. So you don't need a whole lot of ad valorem tax if you're getting that kind of income. So the things that they've done in the past come awful close to the line. But part of the problem is, again, when you think about it, there were 456 people. The mayor's family probably controlled 15, 20%, maybe a little more of all of that property. And those people in town either tended to work for the mayor's family or live in his properties. The newer folks have been here pretty much from 2017 on. A lot of them are commuters, don't really know much about Pendergrass. Their taxes are low. So I don't think they're on the inside. I have spoken to citizens who are at some of these meetings who were not happy and said they wanted to run for office, et cetera. But if the mayor is appointing people to seats instead of holding special elections, it gets hard to run.
Ms. Raines, thank you very much for your comments. Anybody else have any questions for her? Thank you very much. I think we're not going to take action on this. I think there's too many legal questions that are there that we need more research in before we could do anything on that one. Thank you. Representative Thomas, how about talk to us about 243, please?
Mr. Chairman, did you want me to mention 221 again?
Do we have 221?
Yeah, you asked me to do that first and I went to 222 so my folks could leave if they wanted to.
Just a minute. This goes back to title, that chapter 66. Okay, go ahead and present that one right quick, if you will, then.
This is the second meeting for 221. You heard it last week. This would cause cities and county governments that have zoning boards or development authorities whose actions directly affect the property tax, school tax for individuals would have to, we would have to have a member either appointed by the school board or a school board member on those boards to give the school systems a voice in those decisions.
Okay, does anybody have any questions? Does anybody on Zoom have any questions?
At the appropriate time, Mr. Chairman, I'd like to make a motion. If the chair is willing to consider a motion at this time.
Is there anyone here that wishes to speak for or against this bill? 221? Yes, sir. You'll state your name.
Yes, sir. Mr. Chairman, Larry Ramsey with ACCG. You heard me last week speak in opposition to this bill, so I'm not going to repeat all that. Just one point to reiterate. This is the type of issue I think in most places around the state gets handled, right? That counties and cities work with their school districts on zoning issues to take into account the impact on the schools. Just like in most places, the school system works with the counties and cities for new school facilities. You know, counties and cities don't get a say, and theirs aren't subject to zoning. So again, just to reiterate what I said last week, this puts the schools into a position of having a say in zoning of private property when there is no similar reciprocity when it comes to where schools will be located. Counties and cities don't have a say in that. And so we think this is probably an issue that has become a local issue, I'm guessing in Representative Benton's district. But I think in most places, this is not a problem that needs fixing statewide. So we just wanted to reiterate our concern about this bill. And thank you, Mr. Chairman.
Thank you very much. Any other committee member have any questions, comments?
Mr. Chairman, members of the subcommittee, I'm Tom Gale with Georgia Municipal Association. We share the concerns that ACCG has. And I think it's really telling to this subcommittee to see that the School Boards Association is not here in support of this legislation. And I think that that's because the conversations, the dialogue that occurs across the state are productive, and this is not an issue that has statewide need of a solution. Thanks, Mr. Chairman.
Thank you. Anyone else have any questions, comments?
I wanted to mention that the School Board Association was not here last week because most of their executive people were quarantined because of COVID. So I got an email from them on that.
I think we're just going to hold off on that one too, Mr. Benton, and come back to that. Thank you. Representative Thomas, if you'll present your bill 243, please.
Thank you, Chairman Williams. Thank you all at the committee for taking the time to listen to my bill and taking it into consideration. This is my first time ever presenting a bill to a committee, so take a gentle on me. I didn't realize that the term annexation was such a hot button issue for so many people, but you know, I guess trial by fire. So, but my House Bill 234, it's a housekeeping bill. It's nothing more. Currently, the method for annexation by 100% landowners allows for two different set of rules and requirements. And this bill seeks to define one set of rules and to better clarify the spirit of the law. I actually made a couple little handouts. I apologize to those who are on Zoom that you do not have these available to you. It would look like this. I'd like to direct all of you to the sketch I provided to the committee called Annexing Individually. Okay. Now, if each one of these parcels who are hatched in different hatches were to annex one by one individually, the first parcel of property would meet the 50-foot contiguity requirement. And therefore it would be okay under the current statute. The second property, as you can see, I put a dimension here less than 1 inch, would not be eligible, nor would the third if they were to do it independently of one another. So we have parcel 1, parcel 2, and then parcel 3. And I know this is a little confusing. So be happy to take some questions about this after we're over with. Now, subsequently, I have a second one that says annexing at one time. Okay. In this particular case, all 3 of these parcels it's okay for them to annex under one application because the first property meets the 50-foot contiguity, even though that the subsequent second and third do not. And that's what this bill actually goes to address. Now, if anybody is curious where this 50-foot rule come from and how all this came to be, it was originally called spoke annexation. It was to eliminate spokes, right? Well, what's happened is with the way that this current rules are written, all it does is move the spoke to the next property. Okay, and I hope that makes sense to everybody. So, and then effectively what happens is by doing this multiple parcels at one time method, it skirts the original intent of the law in question. So I thought instead of us talking specifically about mom and pop and them wanting to annex into a property into a city municipality, instead what I did is I wanted to do a small case study. And if you look, you have a document on the bottom right corner. It says Z103. Hopefully that's available to everybody. As you can see, this particular annexation was done by the city of Woodstock, and it actually strings together multiple properties with the intention to actually develop the property at the very end, this large piece of property that's quite a bit farther away from the original city boundary. Now, as you follow through these parcels of property, there's one that's called David Porter, and there's another one called Greater North Georgia Charities. There's a boundary there. Now, that boundary is only 37 feet. Now, there's been quite a bit of debate on this, whether it's this or that, but at no point is it above 50 feet. And I have multiple surveys showing that. So what's happening here is we're working through a loophole to annex all these properties together that wouldn't necessarily be eligible to annex. Actually, they aren't eligible to annex under this 50-foot rule. So all my bill does is just say that every parcel property has to meet one set of standards. That's the 50-foot rule that's already been agreed to, or 1/8 aggregate boundary, whatever's less. So, and it just carries through every parcel property. You don't get a freebie because you're the next property down even though the first property meets the contiguity rule, you're 5 down. Well, you're okay because the first property does. And that's kind of the basic of my presentation. Be happy to take any questions.
Okay, thank you, Representative. Anyone have any questions? Chairman Collins.
So as it stands now, in order for property to be contiguous, from a standpoint of legality, you have to be able to walk from one piece of property to another. Would you agree with that?
Yeah, I would agree. So if for the first property to be contiguous,
right,
then you would have to walk from the city boundary into that property.
And the subsequent second or third property. Is that correct?
That is correct.
Under current statute that we have now.
That is correct. So if they don't touch, obviously, then it would be an unincorporated island.
That's what I was getting at. Thank you.
And
anyone else have any questions?
Mr. Chair, can I say one more thing?
Sure.
This rule, as it's currently written, would allow for 2 pieces of property to touch by the thickness of a human hair, whereas this 50-foot requirement, all it does is say this is the minimum you have to touch, and that's all. So again, I said it's a little bit complicated, but I try to make it as easy as I could. So if there's no more questions, I'll be happy to sit.
Okay. Does anyone else wish to speak for this, against this? Yes, sir. Brad, Representative Thomas, you'll step to the side.
Yes, sir. Thank you.
Thank you, Mr. Chairman, members of the subcommittee. My name again is Tom Gale with the Georgia Municipal Association. And in the 2007 session, a grand compromise was reached between ACCG and GMA on multiple changes to the annexation statute. The deal was negotiated at the time by the ACCG president at the time, Sam Olens, who was the chair of the Cobb County Commission, and the mayor of Camilla, who was the president of GMA, who became Representative Jay Powell. Since that time, the annexation law has been working really well. The hour's late. But I would suggest to you all that the 100% method annexation law has been working well, because 100% of the people who own property make a petition to the local city and want in for a variety of different reasons, whether it's better service, police, fire, higher ISO rating, whether it's water, sewer in many areas of rural Georgia, or in developing areas like Cherokee County, where a county government may have a zoning ordinance that requires only one house per 5 acres lot, whereas a city may want more affordable housing, more density. The landowners, parcel owners, will annex into the adjoining city for that reason, to better use their property. My suggestion to this subcommittee is to consider, because we were in 2007 bringing to the General Assembly changes to the annexation law based on a hard negotiation with ACCG, that if there were going to be any changes considered, I would respectfully request that you all direct GMA and ACCG to embark on discussions again on whether or not the annexation law needs some tweaks, and have us go through a process to then come to you all, hopefully arm in arm, rather than having to do tweaks here and there moving forward. So that's my comment on this legislation. We do have concerns and would hope that you all would hold the bill in subcommittee.
Thank you. Yes, ma'am, Chair Lady.
I just want to make sure that you agree that this is an accurate representation of the law. That's what I want to make sure.
So I don't know. I think Representative Collins, that may be a little bit of hyperbole. The human hair test, I think, is something I've never heard of before. But I think Representative Collins has a better analogy for it. You walk from one property to the other. I think that's a better representation of how these things work.
You can do this one at a time. You just can't do it serially, is basically what he's saying.
Other way around.
Say that again.
Oh, that's okay. Thank you.
Okay.
Thank you. Let's see, we have Mr. Warren Johnson, City Council member.
Thank you.
City of Woodstock. Is he here on Zoom? On Zoom. Can you unmute yourself, Mr. Johnson?
Yes, sir. I'm sorry. I'm unmuted. So good afternoon, Mr. Chairman and committee members.
We can't hear you. Mr. Johnson.
Can you hear me? I'm unmuted.
Yeah, keep trying. What about Harry Johnston? Can you?
Yes, sir, I'm here.
Are you there?
Can you hear me? I am here and I'm unmuted. Can you hear me?
We can hear you on Zoom.
Okay, bear with us just a moment. We may be. May have. May have. It's 5 o'clock.
In the meantime, with the CCA month.
Thank you, Mr. Chairman. Larry Ramsey again from ACCG. Most of us had masks on and can try to keep a straight face as to whether you think annexations work well or they don't. That's probably just in the eye of the beholder. I know we have a lot of local government alumni on the committee, so you've seen it from both sides. And I think in many cases it does work well. I was certainly not part of the 2007 discussions, but I agree with Mr. Gale that when it comes to annexation issues, that hopefully GMA and ACCG would, we do work well together, and hopefully we'll continue to work well together on this issue and other ones. I do thank the representative for bringing this issue. I think it's an accurate representation to your question, Representative Oliver, of what the law allows now, that the contiguity requirement, the 1/8 boundary or 50 feet, applies only to that point at which the annexation touches existing city limits. And as you move away from that, if there are multiple parcels as part of one annexation, it can, I don't know about human hair, is probably a reasonable, as long as it's contiguous and there's no beyond that first point, it doesn't matter how narrow that contiguity is. So you get some of the examples that you can see from city limits maps where you have very narrow points where annexations continue. That is allowed by law now. It can, in given cases, lead to concerns about service delivery when you have city limits that extend extensively to capture a development farther down the road. I think this is a real question. We hear this from a real concern. We hear from members periodically throughout the state. We are open, as we always are, to discussions with the author, with GMA, with the committee, to try to find ways to address this issue and other annexation issues, and are happy to be a resource to the committee in any way we can, and happy to try to answer any questions.
Thank you.
Thank you, Mr. Chairman.
We've got feedback. Warren Johnson, are you there, Mr. Johnson?
Yes, sir. Can you hear me?
I can. Go right ahead, sir.
All right. Thank you. Good afternoon, Mr. Chairman and committee members. My name is Warren Johnson, and I am a city council member from the city of Woodstock, where I've served since 2014. I appreciate you letting me speak regarding House Bill 243. I'm testifying today because I, along with the mayor, my fellow council members, city and staff of Woodstock, are all opposed to this bill. As mentioned, it does come out of an issue that is specific to Woodstock. And by way of history, the city approved the annexation, requesting the annexation request totaling approximately 145 acres in 2019, using the 100% method, which, as mentioned, means that 100% of the property owners in the area of the annexation requested to be annexed into the city. So at the time of the request, Cherokee County did not object legally to the annexation request, even though the process does exist to do so and is outlined by existing state law. Instead, they chose to file a lawsuit against the city over this annexation. And that filing occurred after the annexation was legally approved by the Woodstock City Council on a vote of 4-2. Since then, the city has prevailed both in the trial court level and in the Georgia Court of Appeals, because we have followed the law. So I actually was one of the 2 council members who voted against this annexation, but today I'm here speaking in opposition to the bill because it erodes local control, which is a long-held tenet of the Republican Party. And it infringes on property owners' rights, who in our case requested this annexation. The issue is about the owner's right to choose the future of their property, which HB 243 denies, It denies the property owners the opportunity to request annexation and to choose the jurisdiction in which to develop by changing the annexation process and making it much more difficult, much more time consuming, and much more expensive. Annexations are not often about individual parcels, but they're about a conglomeration of parcels which become the annexation area. Excuse me. Annexing parcels by as HB 243 would mandate, denies the property rights of owners who would otherwise seek to annex and develop or redevelop a multi-parcel site, which is the most common type of annexation. Historically, the annexation process has been a delicate balance between cities and counties, and most often GMA and ACCG try to work out a balance and to assist the General Assembly. To my understanding, that has not been the case with HB 243, which is very troubling. We recognize that Representative Thomas is opposed to this specific annexation. And to be clear, I was opposed to it as well, and I voted against it. However, I do not believe that this is the appropriate process for addressing this issue. And if this bill is passed, it will drastically affect local control and the property rights of every Georgian. Thanks for the opportunity to speak.
Thank you, sir. Thank you. Okay, we got a Mr. Harry Johnston. Can you wrap it up? Within about 5 minutes, we've run out of time. Mr.
I will
Johnston,
certainly try.
There.
I am here. Can you hear me okay?
Yes, sir. Thank you. Go right
Thank
ahead.
you, thank you, Mr. Chairman, members of the subcommittee. I appreciate the opportunity to speak with you. The court cases that have been mentioned are in fact the catalyst for the need, require the need for this change. To my knowledge, this bill goes back, the 50-foot requirement goes back to 2000, when a series of changes was made to state annexation law with the intent to reduce inappropriate annexations. That is annexation of property that is not logically or geographically closely related to the city. Among other things, the stem and spoke annexation was removed. Also, the 50-foot requirement for contiguity was added. Previous to that, it was just any point. It could point width of a hair, whatever you want to call it. So the 50-foot requirement was added. And as far as I know, there has never been a case until now that questioned whether that 50-foot requirement had to be included in a chain annexation. Now, I might note that chain annexations are generally considered undesirable because they are a type of stem and spoke annexation. They lend themselves to annexation of property that is distant from the core of the city and surrounded by people who are not in the city and are therefore disenfranchised because they can't vote for or against their city council representatives. They're not in the city, therefore they have no control. The counties have little or no ability to oppose these annexations unless they fail to meet county law, state law, which we believed this one did. And in fact, as far as I know, from 2000 until the point of this annexation, this particular point had not been questioned. If you annex a single property, it must meet by 50 feet. We thought, and I believe everybody thought, including Woodstock, that a chain annexation had to meet 50 feet at every step in the boundary. The need for clarification comes from a clause in the current statute called the single body clause that says that all parcels to be annexed shall be treated as a single parcel. But the location and the apparent intent of that clause in the statute applies to the process. That is to say, you don't first have to annex the first link in the chain, then have the second parcel apply to be annexed, then annex it and have the third and so on and so forth, taking a period of month after month to complete. We don't disagree with that. For time efficiency, sure, annex them all at one time if appropriate to do so. But the 50-foot requirement for contiguity that was added to the law in 2000, we believe applies to every link in the chain and was clearly by the positioning intended to apply to every link in the chain. As far as I know, nobody has annexed a property that didn't since 2000 until now. So what we have is a new case that has been interpreted by the courts. We disagree with that interpretation. I think most people would have disagreed with it prior to this annexation. in this court case. So what we're asking for is just clarification that says that even in a chain annexation, the contiguity and notwithstanding the one body clause elsewhere stated in the law that applies to the process, not to the contiguity, that every link in the chain should meet the 50-foot test. Now, let me say that Cherokee County, and in fact, most counties don't object to annexations that represent reasonable, orderly growth of cities. That's normal and natural. We support those, in fact, in most cases. What we disagree with are the ones that reach far, far out into the country and are surrounded by people who don't have any say in the process and strongly oppose it. They ask us to help. We can't do it. We have to refer them to their state representatives, and thankfully, Mr. Thomas has agreed to try to help with this clarification. To a point that was raised earlier, can you walk from the city of Woodstock to this property? That's a very interesting question in this particular case, because you literally cannot. You have to swim. You have to be able to swim, because the only connectivity of this property to the city of Woodstock is across a river and into the back of a development corridor that's in a totally different area, Highway 92, the Highway 92 corridor, a corridor of a very different nature. If you want to drive to you cannot drive from the city of Woodstock, nor walk from the city of Woodstock to this property. You have to cross a river, and the only way to drive there is to go through about 2 miles of unincorporated area. Now that's the specifics of this case, and that's not so much the point. It just paints the example of what happens if we allow annexations that don't at least meet the basic level of the tests that were intended by the 2000 amendment that added the 50-foot requirement. So I ask you to add that back, clarify it so that it means what we all thought it meant before, and that is that every parcel requires 50 feet of contiguity, and that's just reasonable. It's reasonable and should be necessary, and it's in the interest of the people of Georgia. So that's all I've got to say, but appreciate you hearing me, and I ask that you move this bill forward.
Thank you, Mr. Johnston. I appreciate it very much. I think what we're going to do is probably ask Representative Thomas and GMA and ACCG to maybe have a meeting and talk about this. And I just refer back to that and retain that local control. But I'd like for y'all to do that. So at this time, we won't take an action. Well, I want to know if Jay can walk on water or if he just knows where the rocks are. With that, ladies and gentlemen, we're just going to